Good morning, sir. Are you Kelton Hebert?
Yes, ma'am.
And Mr. Hebert's charged with evading arrest or detention with the use of a vehicle in 24 DCCR 1498. And what is the announcement?
Judge, we have received the discovery and I've gone through it. It does appear that there are some recordings that were missing from the discovery that were not given to the district attorney's office. So I would like to request that from them and see if that those recordings do exist or not.
Okay.
We've had that conversation, Judge, and I'm not opposed to a reset so that we can track that down.
Okay. I'll just do a normal reset, give y'all some time to try to get that taken care of. And then, so Mr. Hebert, stay in touch with Mr. Galmore. He'll let you know when he gets that information so y'all can go over it and we'll see if we can get an announcement at the next court date.
Yes, ma'am.
All right. You're free to go. Thank you. Good morning. Are you Seneca McDaniels? And Mr. McDaniels is charged with unlawful possession of a firearm by felon in cause number 24 DCCR 1915. And Ms. Holmes, what is the announcement?
Yes, Your Honor. We're trying to work out some logistics. We've gone over different ways to get this disposed of. But I think if we, by the next court setting, we will have it done. If possible, it may be reduced. But if we could get a little bit more time.
All right, so I'm going to reset it one more time. This will be the last one. So y'all work out what you need to if you can. If not, we'll get that announcement the next court date. Mr. McDaniels, make sure you stay in touch with Ms. Holmes so you can go over everything with her prior to that next court date, and we'll get an announcement on what's going to happen with your case. All right, you're free to go.
Okay,
Thank you.
thank you.
Let's see, have we seen Mr. Jeffries or Mr. Adams?
Mr. Kelly's here for Mr. Jeffries.
Okay.
Here for Mr. Jeffries.
Good morning, Mr. Kelly. On David Boyd. Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd is charged with deadly conduct, discharging a firearm, in cause number 250720. And Mr. Kelly's here for Mr. Jeffries. And what is the announcement?
I think that there is some media, either video or USB, that we might need to get the marijuana with.
Are you talking about additional media or just the media in the case?
Just the media.
Okay.
Do we have it already?
I'm not sure. I thought maybe you were suggesting that there was something out there that we procured. I'm sorry.
All right, I'll just do a normal reset. Make sure Mr. Jeffries gets that request in. Mr. Boyd, stay in touch with Mr. Jeffries so that as soon as he gets all that discovery, y'all can go over and we'll try to get an announcement at the next court date.
Yes, ma'am.
All right, thank you. So, hang on. So, Ms. Eaglin, you were truthful in what you tested positive for, okay? Here's what I'm going to do. Typically, if someone tests positive for what you tested positive for, they'd be going to jail today. But I'm not going to do that, but I am going to order some very specific bond conditions. One of those is that you are going to have to get a drug patch. You have 24 hours to get that.
This is the moment where everything changes. The defendant openly admits to relapsing and testing positive for PCP, and that admission carries serious legal weight. In court, honesty can help, but it also confirms a violation that the judge cannot ignore. At this point, the judge is to balance two critical factors: public safety and the defendant's need for rehabilitation. Notice how the judge immediately focuses on specifics: what substance, when it was used, and the current condition, because those details directly impact bond conditions and future rulings. Emotionally, this is a breaking point. You can hear the stress, the personal loss being mentioned, and the struggle behind the relapse. But legally, the court must stay grounded in facts, not feelings. So here's the key question. Does the court punish immediately, or does it create a path for recovery under strict supervision? Watch what the judge does next, because this decision will shape everything moving forward.
4 hours to get that. Your bondsman can let you know where to get it. It's a patch that you wear on your arm. You have to get it changed every 2 weeks. It's obviously going to test positive this first time, but it needs to test negative after that. Do you understand? And also, I'm going to order, at least for now, that you are not allowed to drive. Okay? You need to get a ride until you test negative for a little while. Okay. And then you're going to have you visit with the people you're going to visit with this morning, hopefully get a plan together. And as a condition of your bond, you're going to be ordered to follow whatever plan. Make appointments, go to Spindletop, do whatever you need to do, okay? Because we want to get you back on the right path so we can take care of your case. So, well, they're going to give you some resources and where to go to try to get some help so that you can kind of get yourself together so you can work with Mr. Rojas and get your case taken care of, okay? It's okay. So look, have a seat over there, but make sure between today and tomorrow you get that drug patch put on. They have a list over there. Okay. That's where you can get it taken care of. So when you're done with court, find out where you can get it taken care of and get that on before tomorrow, okay?
Thank you.
All right, just have a seat back in the jury box until you visit with Spindletop, please. Thank you, Mr. Rojas. Mr. Lofton, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You need to speak up, please, sir. And will your client waive the formal reading of the motion?
Yes, ma'am, we will.
Mr. Lofton, in cause number 16-24485, I have a motion to revoke your community supervision. Shows that you were placed on probation February 21st of 2020 for the offense of assault family violence, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated second on December 15th of 2023. And is that true or not true?
True.
And count 2 alleges that you failed to pay your court-assessed fees as directed, and as of December 20th of 2023, you were $5,946 behind. Is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
This one.
And did you plead true to those counts because they're actually true? So I'm going to find that you enter those pleas true freely and voluntarily, find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and have the probation department do an updated pre-sentence report, give me more information about what's been going on probation with the new case and everything like that, and then we'll come back at a later date for sentencing. And so you need to stay in touch with your probation officer, stop and talk to the one here in courtroom before you leave today.
Judge, it's my understanding that he's going to plead to a short jail time down in misdemeanor court. Obviously, you have to do at least 72 hours, probably about 10 days. So he may be in custody when the update PSI comes back.
Okay,
And that is in contemplation of the fact that if the court agrees after the update, he will go to ISF and spend additional time in custody.
in the substance abuse track, I would
Yes,
think.
substance abuse track with an extension of his probation, because obviously it was just told by the motion, it's already
Right.
expired.
Okay,
And Your Honor, just for clarification purposes, is my understanding from talking to the misdemeanor prosecutor that that any time he spent in an ISF would count toward whatever sentence they assessed down the hall.
okay. So let's do this. As soon as that happens,
Which is set on the 25th.
25th.
okay. So let's reset it just 1 week after that. Can y'all get that done in a little shorter time as on the update? It's okay. It's an update, so it's, because I also want to make sure,
So if it's after the 25th, the following Monday, we'll not do it, it has to be September 8th.
Is there any way we could,
We might could put it on the 2nd. That's a Tuesday. If he's in custody, we could put it on that Tuesday.
do we have a docket that day? Let's do that.
I am,
September 2nd? Yes, ma'am.
I am set for trial on September 2nd in Jasper. Is there any way,
What about the 26th? Are we here?
Yes.
I'm fine with that. Of August? That's fine with me.
Is that okay for an update? Okay, we'll do it on Tuesday, August 26th. And that'll give you time to get that one, and then we'll need it be on a Tuesday anyway, now that I'm thinking about it, because he'll be in custody.
Right.
So, yeah, okay, perfect.
So
All right.
I need to go for that hearing on the 26th. Will I just go to the jail and do it?
They'll bring them over.
Oh, okay.
Yeah, we're bringing them over. So we'll see you on Tuesday, the 26th, once you're in custody. And we'll get
I'm
that
not going
update.
to
Not you. You're like, I'm going home. You're not out the door yet, Mr. Barrington.
Don't tell my lady.
You're free to go.
I agree with you. Thank you, Judge.
Thank you. Case number 24 DCCR 2310 on Ciandre Stevens. And are you Ciandre Stevens?
Yes,
Ciandre. Sorry. And Mr. Adams, will your client waive the formal reading of the indictment?
Yes, he will.
Ms. Stevens, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from October 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Adams?
Yes,
And do you fully understand them?
correct.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Answer out loud, please.
Oh, yes, ma'am.
Thank you. The court reporter's taken everything down. And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Correct.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I have to ask everyone that. State tenders number 1,
No objections?
it's admitted. Is there any evidence that Ms. Stevens is not competent?
None.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to
Every courtroom decision carries consequences, but sometimes the biggest test begins after someone leaves the courtroom. Today's case showed how honesty can open the door to a second chance, but only under strict conditions. If you enjoy real courtroom proceedings and legal analysis, be sure to subscribe to Courtroom Confidential Legal. Thanks for watching, and we'll see you in the next case.